Friends, today we are discussing about a judge's opinion regarding the corruption in Patna High Court, and of course the judge ordered for a CBI inquiry also in this matter. He has taken up the matter while disposing CRLMP number 4117 by 2018, which is an anticipatory bail petition filed by one KP Ramaya, a retired IAS officer, and while rejecting the bail, and of course already he has disposed of this petition on 23/8/19, and subsequently once again he has taken up the matter on 28/8/19 and ordered for the CBI inquiry, citing it is an open secret about corruption in the High Court of Bihar, or Patna High Court. He commented like this, for which the 11 judges bench of this Bihar High Court under the auspices of Sri Amiteshwar Prasad Sahi, that is Chief Justice of Patna High Court. They have taken up the matter sumoto in re Supreme Court High Court 11 judges bench versus Union of India on 29/8/19 and restrained the so-called judge from functioning officially. That means they have withdrawn all his work. So the name of the judge is Mr. Rakesh Kumar, who worked as CBI standing counsel for 12 years. Then he joined as additional judge in Patna. Now he is elevated to the post of a regular judge, and he is going to retire by January 2020 or so. Now, if you go into the background story as to what is this petition, how these things happened. So let us have a background story. So the story runs like this. Mr. KP Ramaya, who is a retired IAS officer, while working, he is alleged to have swindled or to have caused the so-called breach of trust and misappropriated the amounts relating to SC/ST supply. Actually, he has usurped the so-called SC/ST plans, and a case of the vigilance people filed case against him, and he moved hither and thither to get bail. Of course, he came to the High Court also, and he went to the Apex Court also, I believe. But anyway, his request for bail was not granted. On 23/8/19, the so-called Justice Rakesh Kumar, he denied bail and denied anticipatory bail under 438 CRPC to the so-called retired IAS officer KP Ramaya. What happened is, on the very next day, he surrendered himself before the lower court, that is Vigilance Court in Patna, in the absence of the regular judge. We don't know why, but the regular judge was not present. He went on leave for the particular day, and he surrendered before the in-charge judge, and he was given bail on the same day. This caused ire to the so-called judge. Then he called the so-called registry court master to once again bring the anticipatory bail petition in CRLMP number 4117. He studied it, and on 28/8/19 he passed scathing remarks, wild allegations against the judiciary, and he got it uploaded in the website after 1 hour. So this was listed as matter number 1 on 28/8/19, and it was widely published in the newspapers like Times of India, Dainik Bhaskaran, Dainik Jagran, all these things. They have immediately reproduced almost all the contents of the all the contents of the judgment passed by him, or the orders passed by him. So in the judgment or in the order, he has leveled wild allegations regarding the corruption in the judiciary. He has found out 4 points. Of course, we'll discuss them tomorrow, later in the later course. But he has very vociferously stated that corruption is common in the judiciary in Patna High Court, as well as the subordinate judiciary, they are being protected by the higher ups in the high court, even though they are corrupt, even though there are allegations of misbehavior or something against them, the subordinate staff are being protected by the higher judiciary because of the corruption linkings. That is his opinion, right? So now here, to the surprise of the judge, Justice Rakesh Kumar, what happened is, even though he did not grant bail, the so-called Ramaya surrendered before the lower court and got bail. So how this thing, he wanted a CBI inquiry into the total incident as to how the incident took place, because incidentally the concerned judge of the so-called vigilance court, he was on leave, so in charge man was there and he granted bail. Normally even in the lower court also, the in charge judges or in charge magistrate, they don't venture to take up the matter, they don't venture to take bail petitions also. Of course, all of us know that it is the discretion of the jail, discretion of the judge, whether to give bail or not. Of course, they have got only self-restraint. Judiciary, press, they are self-restraint, that more than that we cannot give. So there is no guarantee that the bail petition refused by the so-called Supreme Court opinion, it can be accepted by a simple magistrate also. There is no wonder, it can be done. But the motives that were attributed by Rakesh Kumar is regarding the corrupt activities or corruption in the so-called High Court judiciary. He has cited 4 examples. Number 1, while he was working as the CBI standing counsel, on one holiday when he was in the house, a senior advocate came to him and served him with the bail notice and also told him that he had a discussion with the senior judge, and simply if he comes to the court and says something, the bail will be granted. Please come. Actually literally forced him to come to the house of the judge because that day was a holiday. But of course he has he has returned the file and he did not even sign on it. And on the next day, the pleader clerk, literally threatened this Rakesh Kumar, who was the CBI standing counsel, that it is your duty to receive the petition. Whether you attend before the judge or is a different thing. Why you have failed to receive the petition, all these things. The pleader clerk literally frowned upon him, of course, for which he approached a senior judge, 2 or 3 senior judges also, he named them, and they advised him, since the issue is relating to coal mafia at Ranchi, so they have advised him and he filed a petition before the judge that since it relates to Ranchi issue, the matter may be transferred to Ranchi bench of Patna High Court, and of course it was done. The matter was finished. The second issue he stated is that regarding the allocation of the bungalows. So he was one of the members of the purchase committee, and he has leveled so many allegations regarding the corruption in the purchase committee, bungalows allotment, all these to the judges and all these things. Third one is the most serious allegation that the judges are reserving the judgments and they are not at all filing the judgments. Today they reserve the judgment and they transfer and get away. And even after 1 or 2 years, 2009 matter was disposed, reserved, and in 2017 the judgment was. This is all because of the corruption. And also the fodder scam judge, the judge involved in the trial of the fodder scam, his wife was elevated to the rank of a Rajya Sabha member. And the last allegation is, so it is also, yes, definitely. The fourth allegation is, of course, it's not that important, but anyway, allegation number 4. In Bihar, there is a judicial academy. So one of the wards of the serving judge, he became a member of the Judicial Academy, and that means he is working as a professor. Of course, maybe against the norms in the view of the so-called judge. So with these 4 instances, he says that because of the corruption, all these things are happening, and surprisingly, because of the protection given to the junior subordinate staff, they are actually dancing as they like, and they are giving bails like this, his opinion. Alright, so now the 11 judges bench of the Patna High Court, they took a serious view, and they are of the opinion that the so-called Justice Rakesh Kumar committed gravest error by assuming jurisdiction. It is quorum non judice. That means even though he does not have any jurisdiction, because the petition was already disposed. 23/7/19 itself, the petition was disposed. But still he has got back the document and he has written whatever he wanted to write regardless of it is his personal. But please remember, the language and the tenor should be like that of a judge. That is what is called a judge's propriety and sobriety. He has to maintain. He has to maintain the self-restraint. He cannot write whatever he likes. So, in the opinion of the judges, the writings or the order of the judge is like that a comrade, a revolutionary comrade. So they say that he actually he wielded his pen. He wielded his pen like an unmerciful sword as that of a committed revolutionary leader who has set out to change the history by flouting the standards of judicial propriety and sobriety. So this is what they thought, very serious issue. So normally it is they think that it is out of his personal frustration or personal vendetta or personal vengeance he has written all these things because he has leveled allegations not only against the serving judges and also the dead. Normally, so that he already told you that dead persons they have got a right to reputation. You should not spoil their reputation. But he has commented badly on them also, and everybody has commented regarding corruption. So the court is of opinion, the judges bench is of opinion. He was one of the members of the purchases committee for the allotment of bungalows, and he worked in the CBI for so much of time. So then as regards Judicial Academy, of course, because of the efficiency, where is the guarantee, where is the rule that a judge's son cannot become a judge, or where judge's son cannot become a magistrate, or judge's son cannot become a professor in a university? It's all atrocious. So they did not accept his contention, and now they have withdrawn all the work allotted to him. Now, what happens? Here the main point is, previously we have seen the case of Mr. Kannan. He has also made so many wild allegations. He has approached the National Commission for SC/STs, all these things, and ultimately he was convicted for the so-called contempt of the court. Of course, the court's left over for the judges is only to get impeached, that's all. Nobody can do anything for him, but they can take administrative action. So here, what the benches say, what these 11 judges think says is that he cannot assume the charge of a judge in his, that is non-quorum justice, we have told him. And he should not write like that. He has got any, if he has got any grievance like that, he should approach the boss, that is Chief Justice of Patna High Court, and he should have given a petition on the administrative grounds. These allegations can be looked into. But this is an outcome of his personal pressure. They also stated that suddenly jumping in the sky to get fame in the yellow pages is also dangerous, because Bible says that one who judges others condemns himself, and the word spoken by him will fly like an arrow. So they should be very cautious in their verdicts, in their words. So please remember. But of course, all these discussions were made, but no inquiry was ordered about the allegations leveled by the so-called Justice Rakesh Kumar. We don't know what will happen to him. At the same time, normally, according to the principles of natural justice also, even when we worked as government servants, whenever there is an allegation, it should be inquired, whether it is a anonymous petition, pseudonymous petition, anything. But if there are certain allegations, they should be inquired into, and then only a decision should be the outcome. Here, they have not commented anything on the allegations leveled by him. They say that they are all out of view, they are not at all alive, and they are not in the way connected to this so-called anticipatory bail petition. But in my opinion, they should have ordered an inquiry in the allegations also, and they should definitely inquire as to how the bail was got. by surpassing the so-called. Of course, we cannot directly say anything because the judge, he is a judge, maybe a district judge, maybe a high court judge, maybe a Supreme Court. They have got the discretion to grant bail. So when once he surrenders, Ramaya comes and surrenders before the judge, it is the prerogative or the discretion of the judge to grant bail or not, depending on the local circumstances. There is no hard and fast rule that when Supreme Court refuses, the lower judge cannot bail. It is not correct. But anyway, let us have a positive attitude and let us see what will happen to this judge, whether the allegations are correct or whether the stand taken by the 11